Hi, I'm Angela Cavanaugh, the Executive Director of CAI. I would like to welcome all attendees and thank our partners, the Board of Directors, and the CAI team for today's program. Some housekeeping rules. All participants will be muted today. Please type your questions into the question box and be sure to name the panelists that you would like the question directed to. If you need a certificate for manager credits, please email Jackie at Jacqueline, Jaclyn, at CAI-NJ.org. And also just a note that you need to stay on for the entire broadcast in order to qualify for your certificate. A few important announcements. We are now registering for our Fast Tricky Tray. It's a fundraiser for the Make-A-Wish Foundation. All proceeds will be going to the Make-A-Wish. You can register for that either through our website, and it will also be announced in our newsletter this Friday. In addition, we have our next Wednesday webinar, and next Friday we have our next session of the HOA Feud. First, today we'll be hearing from Scott. Scott Pennick is a senior attorney with McGovern Legal Services, where he joined the firm in 2010. Scott's practice is focused on acting as an outside general counsel to community associations through the state of New Jersey. A fun fact about Scott, although he tends to stay away from litigation, in 2015, Scott represented a condominium association in a case that redefined what a condominium unit is in New Jersey and established that owners of these phantom units are responsible for assessments. Welcome, Scott.
Thank you, Angela. So we all, as you might know, got a little gift earlier this year. Before I get started, though, to prove I'm a real attorney, I'm going to have to give a disclaimer. This is not legal advice. It's for educational purposes only. And this presentation or any questions that I answer do not create an attorney-client relationship with any of you out there. So moving on. So in May, we all got a gift because COVID-19 wasn't enough. We got new election procedures. So not only are we now having all these meetings on Zoom, but we have new election procedures. So I want to focus on the things that are new to the election procedure process to leave enough time for any of you that have specific questions. I imagine if you have not had an election yet, since these new regulations went into effect, you might have some specific questions. So I want to be sure to leave some time for that. But one of the critical things in planning and developing election procedures right now is to give yourself enough time. The new regulations are very driven by certain notice deadlines and time periods. So I recommend tabling at least 60 days out from your desired election date to start getting your notices ready and all of that to give you enough time to comply with the new regulations and not be scrambling around to meet your anticipated election date. So I'm going to go through this in order. So the first thing you're going to end up sending out when you're going to have an election is a call for candidates. So that's not really new. And Radburn established the Radburn amendments that preceded these regulations also established these new timelines, but we did get a little bit of clarification in the regulations. So that's one of the good things that came out of these regulations about the timeline. So when you send out the call for candidates, it has to be sent at least 30 days before you mail out the election notice. So that's not new. We've been dealing with that since 2017. You also have to give at least 14 days for candidates to respond to the call for candidates. Again, that's not new, but what is new is we get clarification on the period between that minimum of 14 days for the response time and that 30 days that before the election notice. Because Radburn in the amendments and in the regulations provide that if someone submits a nomination a business day before the election notice is mailed out, then it has to be considered. So the regulations have now clarified that that is only the case if a deadline is not set in your call for candidates. So be sure to set a deadline in your call for candidates so that you aren't scrambling the day before you plan to mail out all of the absentee ballots, proxy forms, and everything, and you suddenly get a new nomination for a new candidate. As long as you set the deadline, and it's at least 14 days from when you mail out that call for candidates, we don't have to worry about now someone sending in a nomination a day before the ballots and notice are about to be mailed out. So that was nice to have that clarification, because we kind of had this 16 days or so in there of, what do we do if people send in nominations during that period? So that's been clarified. Something that remains unchanged is good standing, as defined in the Radburn amendments and in these regulations, is the sole criterion for eligibility to be on the board, to nominate someone to be on the board, and to vote on bylaws amendments, which we're not talking about today, but is also part of the regulations. So good standing is defined as either being completely paid in full, or the person is complying with a payment plan, they are complying with a judgment for amounts due, or the person is challenging, they're disputing their delinquency via ADR or a lawsuit, essentially. So if someone meets any one of those criteria, then they're in good standing to be a candidate or to nominate someone or to vote. So it creates a uniform across the board good standing definition for all of your clients. So if you're a manager, that's one nice thing. You don't have to read separate sets of bylaws or what good standing means. It's defined in statute and regulation. So a new notice requirement that came out in these regulations is that 30 days before the election date, you have to send out a notice to everyone who is not in good standing. And you have to inform them that they're not in good standing, why they are not in good standing. You have to tell them that they have the right to contest the fact that they're deemed not in good standing by requesting ADR. And people have to be given up to, again, this is a new sort of uniform rule, up to 5 business days before the election date to rectify their standing. So that's in the regulations. So again, one nice thing about it is we have these uniform timeframes now. So it's that good standing deadline for people to rectify the issue. It's 5 business days before the election date. So you can mark that on your calendar and check it across the board for your clients. So that's a new notice that has to go out at least 30 days before the election date. It's pretty simple, but it needs to happen, or people could contest the fact that they weren't provided notice and weren't able to vote or rectify their good standing. The notice of election. Again, this hasn't changed a tremendous amount since the Radburn amendments, but it has to be sent at least 14 days prior to the election. So a lot of people may have bylaws that say 10 days notice. Hopefully you've already cleared that issue up over the last few years since the Radburn amendments were adopted. If not, you may want to consider a bylaws amendment to change that notice period, but it doesn't matter what your bylaws say. If they conflict with these regulations, you've got to follow the regulations. It's a minimum of 14 days ahead of the election date where the notice has to go out. And with the notice, you've got to send the absentee ballot and the proxy. So assuming that your bylaws permit proxies, which I'm pretty sure every state does, right? There are certain disclosures on the proxy. Those haven't changed, that you have to tell people that use of the proxy is voluntary and that they can revoke it at any time before the proxy holder casts a vote. One of the new things, though, about balloting, whether it's in person when that happens again, or absentee ballots, is that ballots have to be cast in an anonymous manner. So that is a new sort of procedural challenge for a lot of associations, most of which did not have a mandate in their bylaws for anonymous voting. So what most associations are doing to address this issue is a double envelope system, if you haven't done it yet. So in a double envelope system, just like it sounds, 2 envelopes are used. So you send out the ballot. It doesn't have a unit address or a name on it or any place for a signature on the ballot. I'm talking about the ballot, not the proxy. So someone mails back that ballot in an inner envelope that has their name and unit address on it, right? Because we still have to confirm that people who are voting are in good standing, are unit owners, are eligible to vote, don't vote more than once, right? So there still has to be a way to clarify that. So that inner ballot is a way, we don't see the ballot inside that inner envelope, is a way to check for good standing. Is the ballot inside this envelope from someone who is in good standing and eligible to vote? And do we only have one? Because once we take the ballots out of these inner envelopes that are returned in an outer envelope that of course has the mailing address on it and everything, or if the association has a lockbox or something on site that people can drop off their inner envelopes. By the way, that box has to be locked under the new regulations. Then you don't need two ballots, right? They can just hand deliver their inner envelope, their single envelope with their name and unit address on it. But the ballot inside is anonymous. So once that good standing date has come and gone for people to rectify their good standing 5 days before the election, you can start checking, do I have a ballot inside this envelope that is from someone who is eligible to vote, right? And so you can create piles of eligible and non-eligible voters. And then all the ballots must be publicly counted now. So that has been done during this COVID period via Zoom, where there's a camera on the individuals as they count the ballots. Also had, I believe, some clients do some outdoor meetings that were a little bit smaller, and people counted them at a table out in the open. And ballots must be kept for 90 days. So I've had that question a lot over the years, how long should we keep these ballots and everything and all the election materials? So that question's been answered. You've got to keep it for 90 days. Hold on to those ballots for 90 days, just in case someone contests the results of the election or whatnot. A couple of new things that I want to be sure to point out. If you have affordable housing units, it's important to take note. If affordable housing units are a minority of the units within the association, then they must select at least one seat on the board. So it does not say, the regulations do not say that one seat on the board must be held by an affordable housing owner. They say that the affordable housing owners must select one of the board members. So if you haven't had an election yet, if you don't have bylaws that already provide for this, your next election is probably going to be the election where the affordable housing owners are selecting at least one of the candidates. And so I think one of the most practical ways to accomplish this procedurally is to have two ballots. The ballots are anonymous. However, one ballot is for affordable unit owners, right? It's still anonymous, but it's got some distinction on it that lets whoever's tallying the ballots know that this ballot is from someone who's an affordable unit, right? Because the affordable owners must select one of these seats. And those ballots need to be tallied separately from the gross total of all ballots. And the winner of the affordable tally is automatically elected to the board, whether or not they would otherwise have been elected by a plurality or majority vote of all of the votes. So that's why you need the separate tally for those affordable ballots so that you can see who won the affordable unit owner vote. And that person then automatically, by winning that affordable unit owner vote, gets a seat on the board. You've complied with the regulations, and it's only one seat. It's not every election cycle. So if you have 2-year terms, for example, then it would be every 2 years when that election cycle comes up, that would be when you have this separate tally for the affordable owners. If you've already got someone on the board who is voted on the board by the affordable owners for, let's say, when next year's elections roll around, you don't have to go through this double process. They're not entitled every time there's an election to vote one of the seats on, just one of the seats on the board. So important to know if you have affordable units at your property that are a minority of the units within the association. Some of the other new changes are for appointing to fill vacancies. There's now a maximum term for appointment. So a lot of your bylaws probably provide that vacancies due to resignation or no longer being eligible or anything may be filled by the board. And that is still the case. However, that appointment period now is a maximum of 1 year. So basically, probably a good way to handle this is appoint the person. The next time there's an election cycle, whether that seat would have normally been up or not, put the remaining term of that seat on the ballot for the next election cycle within 1 year of appointing someone if you have a resignation, someone moves, or whatever. Also, very quickly, because I've been given the signal that it's about time for Q&A, is the write-in candidate requirements. You need to have as many write-in candidate lines on your ballot as there are seats open to be elected. So if you've got 2 seats open, 2 lines for write-in candidates. If you have 3 seats open, 3 lines for write-in candidates, in addition to all the other candidates being on the ballot in alphabetical order by last name, not indicating anyone who's an incumbent, being in the same font size and color, all of that stuff that you were probably, hopefully already doing. So now I'll stop and take a chance to answer any questions that anyone might have had.
Okay, thank you, Scott. A few questions, actually. First one, can call for nominations and notice to those not in good standing be mailed at the same time?
As long as, yes, they should be able to be mailed at the same time, because you're still going to be at least 30 days out from the election date. So there's no requirement to mail them after, just that they're at least 30 days out. So you could mail those at the same time, sure. Just don't stuff one of those notices in the wrong envelope with the call for candidates to someone who is in good standing. Yeah.
Okay. Next question, can we still accept ballots via email? A lot of residents don't trust USPS and submit theirs anonymously ballots as attachments.
That's a good question, right? Electronic notices and voting were also addressed in the regulations, sort of enhanced. They were addressed in the Radburn amendments as well. For electronic delivery, so it needs to be a distinction understood between electronic delivery of a ballot versus voting electronically. To vote electronically, it needs to be approved in the bylaws, and the individual owner needs to consent to voting that way. Voting electronically would be getting an email where you sort of click a link and then go to a website or something and then click radio buttons or something like that to select your 2 or 3 candidates. Returning a ballot via email is different. That's just electronic delivery. See no problem with that. People do have to understand they may be giving up a little bit of an anonymity issue, but management or whoever's receiving those email ballots can, print them out, put them in an envelope, write the person's name and unit address on it. So now an anonymous ballot has been printed. We know who it came from because of the email, but we've printed it and either used the email or an envelope in-house to write someone's name on it to maintain that anonymity or some process like that in order to check for good standing ahead of the meeting. But there's no prohibition at all to returning ballots via electronic means, right? So that's different than voting electronically.
Okay. Next, do the new laws regarding elections have different requirements for smaller associations?
Yes, they do. So if you have less than 50 units, so it's less than 50, not 50 or less, so 49 or less, then there are some different rules. The way I interpret the rules as making it a little bit easier on the association administratively. So one of the big differences is the notice of election. It still has to be sent at least 14 days before the election date, but you can't send it any further out than 30 days now, whereas for communities 50 and larger, you can send it to 60. That doesn't really change anything as far as ease of sending it out. So that is different. The maximum time is different. And the notice to the members who are not in good standing only has to go out 14 days ahead of the election, not 30 days. There's also a statement, and there's not a lot of clarity here in the regulations, but that the write-in candidate rules can be governed by the bylaws rather than mandating a certain number of write-in candidate lines for smaller associations. So 49 or less. Those are differences.
Okay, and the last question currently is, given all the new timelines for different notices, what is the minimum and maximum total time frame required for all associations to comply with all of these new notices to hold an election?
So it's a good question because, again, you got to calendar this far enough out. So 44 days is the minimum. And I'm talking about 50 and over. There's a little bit of flexibility on that with the 49 and below. So at least 44 days. So if you're planning on having an election less than 44 days from now and you haven't sent anything out, you got to pick a new election date. You don't have time. And the maximum is 120 days, which seems like an obscenely long period of time, frankly, to drag out the process. But so a minimum of 44 days, a maximum of 120 days.
Okay, that's it. Thank you so much. I'll let you know if any other questions come up at the end. Okay, next we have Brian. Brian Weiner is the Senior Vice President of Brown & Brown Insurance and has been with the company specialized in community association for 18 years. He currently represents 340 communities in New Jersey. His consultative approach with boards and managements always focuses on the education and sustainability. Welcome, Ryan.
Thank you, Angela. So our topic today is just handling the claims process. We can branch off and go in 50 different directions here, and those that know me know that I'm pretty passionate about this stuff and can go on a little bit. So I'm just going to focus on some hot topics and kind of stay above, not getting too far into the weeds here. But liability and property are the two basic, obvious types of insurance that every community has, and those are where you're going to see your claims. I'm going to spend the majority of our time talking about a typical property damage claim, because that's where property management specifically needs to get the most involved, and occasionally the board needs to get involved as well. And you get some frustrated unit owners, and it becomes pretty emotional if it's a sustainable or a large loss within a unit. But before we get to the property piece, I'll just mention on the liability side, there's obviously two types of liability policies that community associations have. A general liability policy, which protects the association for bodily injury claims or property damage claims. And then you have a director and officer policy that protects the board of directors against claims that revolve around their decision making. Okay, I'm not going to tell you exactly when to and when not to submit a claim on the liability side. My approach is a little bit different, so I'm not going to speak for all brokers, but I'll just tell you that you need to contact your insurance broker whenever you get either a threat to sue, if you get a formal summons and complaint, or you get any attorney representation letter from a third party that may be bringing action against the association. Okay, the reason why I'm suggesting contacting your broker and being proactive about notifying an insurance carrier timely is because a duty as an insured is always to notify the carrier timely. And a lot of times, well, a lot of times meaning maybe 5, 6, 7 times a year, which it becomes a difficult conversation, I'll see a community try to handle a situation on their own, or try to handle a situation through their own counsel. And it becomes a bigger problem later down the road, and now a formal suit comes pertaining to the same issue, and the carrier at that point has the option to disclaim coverage because they weren't notified timely of that situation and given an opportunity to address it when it was a smaller concern. So I'll just say on the liability side, again, anytime you receive a threat to sue or a attorney representation letter or a formal summons and complaint, you need to contact your insurance broker and have a conversation as to whether or not it makes sense to notify the carrier at that time. Okay, so just transitioning into the most common types of claims that we need to get involved in is going to be on the property side. You have typical everyday claims and you have catastrophic claims. Just to get the catastrophic claims out of the way, and a lot of times these happen on Saturday morning, so we get frustrated or flustered if you can't get in touch with your insurance company or insurance broker about what your responsibilities are. In the end, your number one responsibility is to take necessary steps to prevent further loss. Okay, if that means calling a reconstruction company to board up a fire unit or calling a water mitigation company to start extracting water, that's your duty as an insured. Okay, you can wait until Monday to notify your insurance company of that issue if necessary, and that adjuster will be out. If it's catastrophic, it'll be out on that Monday or Tuesday, I'm sure. Okay, some things you can do ahead of time. You can have a kind of a preparedness plan, so to speak. especially for those communities that may not have property management representation. You know, the typical managers that we see all the time that are involved in CAI, you know, they know a reconstruction company. They'll know one of those big mitigation companies that they can call right away and have access to that professional to address that. But some communities that they might not have that direct link to an immediate helper might want to put together a preparedness plan and a list of folks that they can contact in an emergency situation so that you can minimize the amount of loss at that time. Okay, but I'm just going to, you know, transition to a typical claims process, and that's, you know, sadly it always revolves, not always, but typically around water damage. All right, and water damage that stems from within a unit. And a lot of times the water damage comes from an item that's maintained by someone other than the association, meaning the unit owner. So failure to maintain items in units, a typical condominium association, will result in a claim against the association if it reaches the association's deductible. All right. Now I'm talking about a typical community where the association is insuring the buildings, including definition of unit, back to the way that building and unit was originally constructed when that first unit owner saw that unit as it was conveyed from that developer to that first unit owner. Okay. So essentially the association's insuring the original construction items that are within that unit and permanently attached, like the flooring and cabinets and countertops and bathroom fixtures and such. So a community that's aging, especially that may be 15, 16, 17, 18 years old, will start to see items within units that may not have been replaced starting to fail. We typically will see a hot water heater, washing machine hose, refrigeration lines, condensation, pipes in the walls, kids overflowing tubs and toilets, right? And negligence does not come into play in a property contract. So there's no wording in an insurance contract that says that, you know, if my 7-year-old daughter, you know, overflows the tub because she left her Barbies in there and filled the water up overnight and I didn't notice for 8 hours, that's not excluded in an insurance contract. Okay, so that's a covered insurance claim. And boards and managers often get frustrated with why, Ryan, are we involved with something that they did or that was in their unit? And we need to realize that we and they are the same entity. The association and the unit owners, when it comes to insurance, when you're insuring a condominium association, are one and the same, and this is their policy, the association's policy, that when it makes sense for them to utilize it, we need to allow them to do so. Okay, and as communities are aging and more items are starting to fail, communities ask what the answer to that problem is. How do we minimize our involvement? And addressing the deductible is where they turn, most of them. We're seeing, you know, what used to be $2,500 deductibles in our industry become ancient as communities have gone to a $5,000 and $10,000 deductible and a per unit water damage deductible for many. And what that basically says is that the association is not going to get involved in an interior unit damage claim unless there's damage to those original items that exceed that deductible amount. So the higher the deductible goes, the more skin in the game the unit owner's personal insurance might have. Okay, and you don't want to get out of control and go from a $2,500 to a $25,000 deductible without proper notification to the owners. We wouldn't want to do that. But it's typical to see, you know, communities go from a 25 to a 5 or a 5 to a $10,000 deductible, and then properly educate their owners about the personal insurance needs or the increases in the coverage A limit on their personal policy that they need to address so that they're properly covered in the event of a loss. Okay, some associations have a deductible resolution that addresses the pass off of that first $5,000 or $10,000 of damage to the unit owner. But I'm just going to give you a typical insurance claim from a numbers perspective to show that when it's an interior water damage claim that stems from within a unit, the association shouldn't be out of pocket anything, and that higher deductible is no more risk to the association's budget or to the board. So if someone sustained a hot water heater damage example and they had $25,000 of damage in their unit, and that association had a $10,000 deductible, we would put a claim in through the association's property carrier. The $25,000 damage would result in a $15,000 proceed check from the association's insurance, since we have a $10,000 deductible. That first $10,000 would get submitted by the unit owner to their personal HO6 carrier. And if that unit owner had a $500 personal deductible, they would be out of pocket the $500, and the other $9,500 would get paid by their personal insurance company. Let's just say, you know, for instance, traveler's insurance, just for the sake of argument. So in a $25,000 loss, the association's carrier pays $15,000, Travelers pays the unit owner the $9,500, and the unit owner pays their $500 out-of-pocket deductible. Okay, association paying $0 out of pocket. So the only time the associations would really be on the hook for that deductible amount and out of pocket against their budget would be if it was a common element or a common area that was damaged in the loss, which we see with common hallways, we see with roofing or siding damage from trees. Sadly, in the past month, that's been the topic of conversation on roofs or other common areas, as well as lightning strikes or wind blowing a portion of the roof off or the siding. That's when you're not going to be able to pass that deductible responsibility off onto the unit owner. And the one last thing that I'll finish with before we bring up any questions would be holdback amounts. When there's a large claim, and this gets confusing, insurance policies pay for replacement costs. And I'm not going to say everyone, but most of them are going to pay replacement costs, which is paying to restore the damaged property to what it was before the loss at whatever the cost is today. That's full replacement cost. It does not take away depreciation. Those that have heard buying a new car, it depreciates and it's worth less by $5,000 the second you drive it off the lot. And property insurance for community associations doesn't take into consideration depreciation, okay? But when you have a substantial loss, let's say you had a $1.8 million fire, the insurance company might send the check initially for $1.5 million, and they might hold back the depreciation, meaning it's just a way for insurance companies to prevent clients, not that we would want to do this, but financially benefit from an insurance loss, meaning get the work done for less and keep the rest of the money. So the insurance world puts this hold back, and they might hold back that $300,000 and then require the insured, the association, to show proof that they completed the work and spent that money, and then they'll release the other $300,000 to you. You'll see that a lot on a claim where there'll be a holdback amount. The unit owner or the association is always entitled to that holdback money as long as you show proof through canceled checks and contracts that you spent that money and it was for the scope of work that the insurance company paid for. Okay. Questions, Angela? Do we have any that you'd like me to address?
First question, how do you define threat to sue?
Good. That's a good one. Okay. So threat to sue, this is a really good one because it happens all the time and we want to minimize putting unnecessary claims in. And a lot of times we will have a conversation with a unit owner or an email where they want an area of their mailboxes to be taken care
of.
Might notify us that they, were injured in that area. But the point of them saying that is for a problem. I just wanted to have that area removed and we, that area addressed. We put it in a file and we're good to go. But if someone shows up at an open session and it shows up in the meeting minutes that they might say something like, my 9-month pregnant wife fell down the stairs that you didn't maintain the ice, and if anything happens to my unborn child, you're going to pay for it, right? That's a threat to sue. It's not in writing, but it's going to show up in writing in minutes. And that would be a recommended area where we would submit the claim to the insurance company right away. Okay, so if there's something in writing that's a threat to sue, we're sending it to the carrier. If it's a conversation and the person just wants some area addressed, and we get something in writing back from them that they're okay and they didn't seek medical attention, put it in a file and move on.
Okay, right. So I hate to do this to you, but we lost you for a second. So just summarize that answer briefly for us one more time.
Okay,
my apologies.
Yeah, so basically a threat to sue in writing or a threat to sue in open session forum that may show in meeting minutes would be an area where I would highly suggest notifying your insurance company. Any type of attorney representation letter that says, I represent unit owner, 124, they slipped and fell last September, please notify your insurance company. You have to send that in. Even if you were not aware of that slip and fall, were never notified of an injury, you need to send that in. Anything in writing that's a threat to sue in writing or representation from an attorney needs to be submitted.
Okay, thank you. Thank you for repeating that. A couple other questions. What can associations do to minimize their total amount of claims?
Okay, a lot. From a risk management standpoint on the liability side, a lot of that stuff is physical that you can see. You know, you can see a 2-inch lip in a sidewalk. You can see a pothole that needs to be addressed. You can see a curb line that's cracking that could provide a slip and fall hazard. Those need to be addressed on a semi-annual basis to address any kind of blatant slip and fall issues. Contract language, sadly, I mean, Scott can attest to this. You know, we do hire independent subs to perform work, and there's great contractors that are doing snow removal, landscaping, roofing, all that fun stuff. But you know, we need those contractors to have skin in the game as well when their employees are negligent in creating loss. So contract language to share in these typical losses is important for associations to enter those correct contracts. And then from a property perspective, you know, there's tons of opportunity to prevent property loss through hot water heater resolutions, which, you know, force unit owners to replace the hot water heaters upon their expiration of the warranty, or replacing their washing machine hoses, or something as simple as having a procedure in place for grilling. Grilling meaning using grills, types of grills at your community, where you can use them, when you can't, and the carriers pretty much are all the same with regards to this. We don't want to see charcoal grills on balconies, right? I mean, we don't want to be frying turkeys on a 3rd floor balcony on Thanksgiving. I mean, I had a $2-point-some million loss from that. So, you know, typically electric grills, natural gas grills on balconies. Otherwise, if we're using propane, it should be on the ground floor, and it should be at least 10 feet from a combustible surface. And if you're allowing charcoal grills, it better be a association maintained, permanently installed charcoal grill area, and not charcoal grills that unit owners can just place anywhere they want.
And we have one last question, if we can do it quickly. What happens in a situation where a homeowner doesn't report a maintenance matter in a timely manner, which caused significant damage, for instance, a roof leak that turns into a mold issue?
Oh, okay. So property insurance claims, in order for a claim to be triggered, it needs to have a couple characteristics that are mentioned in the insurance policy, because not everything is covered. It needs to be sudden and imminent and have direct physical damage from a covered peril. Okay, sudden and imminent. So things like bursts are covered. Things like leaks, seepage, shrinking, bulging, wear, tear, rust, corrosion, all those type of descriptions for loss occur over an extended period of time and are going to be excluded in an insurance contract. So on a roof leak example, when water is coming from the outside and the building does not first sustain direct physical damage from some other peril that creates a hole that allows that water to get in, meaning lightning, tree falls, windstorm, that just water damage through the roof line or skylight or in a foundation for groundwater is not going to be covered by the insurance policy. So the recommendation is always for the association to immediately fix or address the common area that allowed that water to get in. But most times the association is not going to get involved in the interior damage for that unit owner. Okay, they're going to have to go seek coverage through their own personal insurance.
Thank you, Ryan. Thank you very much. Okay, next we have Gabe. Gabe Vitale is of C&L Services Pavement Maintenance, is celebrating 50 years of industry leading service to communities and customers with pavement maintenance solutions that are simple, realistic, and tailored to the needs of their customers. C&L provides paving, concrete, seal coating, crack filling, and line striping services that replace or extend the life of your community's assets. The C&L experience is the difference. Welcome, Gabe. We can't hear you.
Sorry.
Okay.
I had myself muted, sorry.
Okay, go ahead.
Thank you very much, Angela. I'm Gabe Vitale, C&L Services Pavement Maintenance. Put together a short crash course on pavement maintenance today. I know the word gets thrown around a lot. You always hear pavement maintenance, pavement preservation. Not a lot of people and managers, HOAs, board members know what that actually means. So by the time I'm done talking today, you'll have a brief overview of what pavement maintenance is, what's involved in it, how often we should be doing it, what solutions are available to you, and which ones make the most sense for your communities. You guys can see my screen?
Yep, you're good.
So there is a long, drawn-out definition of pavement maintenance. Angela touched on it earlier. Any activity that extends the life of the pavement and improves safety and mobility is considered pavement maintenance. That's a quick, short way to look at it. There are 3 components to pavement maintenance. You have your routine maintenance, you have your repair maintenance, and you have your preservation maintenance. So I will go over them briefly and explain a little bit on each one. First is street sweeping. Believe it or not, street sweeping is included in pavement maintenance. Part of the process that decays the asphalt is the salt, the sand, the cars driving over that salt and sand. It acts as a sandpaper, wearing down the durability of your roads. So by sweeping once a year, twice a year, quarterly, you're removing all of that debris that lives on those roads, all the sand, all the salt that eats away at it, all the dirt that the tires rub into it. And on top of it, you get some nice curb appeal for the community as well. First item on repair maintenance is pothole repair. So under repair maintenance, you have your potholes, you have infrared repair, you have saw cutting repair. All 3 of these occur when the roads in your community start to develop potholes, the asphalt starts to get brittle and breaks. It becomes a hazard to the cars, it becomes a hazard to the asphalt around it. It's important that you stop the failed area, remove it, replace it, eliminate it. Otherwise, it will affect the areas around it. It allows water to get in the ground. So the first one is pothole repair. It's the least expensive, and with that is the least permanent. Simple, very simple procedure. You remove the asphalt that failed, place the new asphalt into the pothole, and then you compact it, and then you seal the edges to prevent the water from getting in there. It's easy, it's effective, but it is extremely temporary. I've seen some areas where it lasts 3 months. I've seen some areas where it lasts a year. You're not going to get much more than that, though. Infrared repair is a process that is moderately expensive, semi-permanent. Short and sweet, you heat up the existing asphalt, soften it. Then you add new asphalt into it, which gets the oils back into the old asphalt, seamlessly fuses it together, and then you compact it again. Last but not least is a saw cutting repair. It's the most expensive, but it is very permanent. You actually take a demo saw, you remove the entire area, all areas that have failed, all areas that have been affected, as you can see in the picture on the bottom right. Make sure the base underneath the asphalt is good. That base is your foundation. If the foundation on a house is crumbling, the house is not going to be standing. Same applies with your asphalt. If the base underneath your asphalt is broken, is wounded, the asphalt on top of it's going to crumble. So first thing you do is you remove all the filled asphalt, you check the base. You compact it, you prep the edges, put tack around the edges for good adhesion, put new asphalt in, compact it level with the asphalt around it, seal the edges. It's a very permanent fix. Last but not least is preservation maintenance, which I would have to assume most board members and managers are most familiar with. This involves seal coating, crack filling, and line striping. So many times throughout, my life and in conversations with managers and conversations with people on the street, they say, why do I have to seal coat? I don't care if my asphalt looks nice. Seal coating's main purpose is not for the asphalt to look nice. What the seal coating process does is it provides a layer of protection to the asphalt. It blocks out the harmful elements. I'm going to go back one step. What are harmful elements? The UV rays, the sun. You ever see the white asphalt that's turned white? That's because the sun has been beaming on that asphalt for many, many, many years, and it becomes oxidized. It protects the water infiltration. So the seal coating will fill the hairline cracks that allows water to get into your base, your foundation. You want to keep water away from that foundation. the oils, the chemicals, the cracking, and normal traffic wear and tear. So although after you seal coat your community, your roadways, your parking lots, your walking paths, your driveways, whatever it is, it does look gorgeous, but that's not the main purpose of seal coating. The main purpose is structural and is keeping those harmful elements away from the asphalt, which is probably your most expensive asset in your community. Next is crack filling. Similar process is usually done with seal coating, but it involves the process of using hot rubberized asphalt filler or tar, fills the cracks in the pavement. So if you see the picture on the right, those cracks are asphalt's worst nightmare. They are direct access to water infiltrating the base. And I keep talking about the base. The base is your foundation. We have to protect the base underneath the asphalt. Those cracks allow water to go directly into the base. Crack filling is a process that should be done every single year. And if it's done every year and kept up with, it's a very inexpensive maintenance procedure. It prevents the intrusion and infiltration of water, the most destructive element to pavement. The more water penetration, the weaker your pavement base becomes. A lot of times the crack fill and the seal coating are done together. They are a seamless process when performed together. Last and not least, line striping. Most people will say line striping does not fall under the pavement maintenance category, because if you listen to what I said under pavement maintenance, it extends the life of the asphalt. Line striping does not do so. However, you cannot seal coat your parking lot or your roadway and not line stripe it. So line striping does fall in, and of course it provides safety, maximizes parking, gives the community some nice curb appeal, provides the handicap spots. It's not an expensive investment, and obviously provides a large aesthetic value. So as I promised, that was a quick crash course on pavement maintenance and what it does for the community. So if you want to bring me back, Angela, I will be more than happy to answer any questions that anyone may have out there involving pavement maintenance and the process of it.
Thank you, Gabe. Yes, we have questions.
Sure.
First one, when is the best month or time of year to complete crack filling?
So I'll give you a direct answer on it. Crack filling should be performed before the winter and close to before the winter season. So CNL does the most volume of crack filling in the months of September, October, and November. You want that crack filling to be fresh, solid, new, just put down before the winter months come, because that freezing and thawing that occurs when that water infiltrates through the cracks into the base is beyond detrimental. Now, off of that, you can crack fill at any time. You should be getting at least a year out of your crack filling process, but the best time is September, October, and November. You got to keep that water out in the winter.
Okay, and then on top of that question, leading into how frequently should pavement maintenance work be performed?
On some level, every year. Street sweeping, we have a lot of communities at CNL that have a biannual street sweeping process. It's an inexpensive service that can be provided to the roadways and the parking lots. You should always be looking at crack fill on a yearly basis. I'll say it again, I've said it 10 times already, you got to keep that water out from infiltrating the base of your asphalt. And then as needed, your pothole, saw cutting repairs, got to cut out those failed asphalt areas. But in some way, shape, or form, there should be some pavement maintenance performed every year. And if it's done on a yearly basis, it's usually a moderate amount that's needed.
Okay, and there is one last question. Can pavement maintenance work be performed without an inconvenience to the residents?
No. The answer is no. In some
That answers that.
in some way, shape, or form, there will be some sort of inconvenience to the residents in all aspects of pavement maintenance. However, it's important that board members and managers select a company that can limit that inconvenience, that can logistically plan the project properly, that can execute on the days that they promise they're going to execute, that can provide different means of communication to the residents. So it can be done in a delicate manner when working with the right company. But the answer is no. There will always be some sort of inconvenience to the residents. And although it's still an inconvenience, the residents usually understand because the final product or the outcome is something that is for the best of their community.
Okay, that's it for now. I'll let you know if any other questions come up. Thank you, Gabe.
Thank you,
Now
Angela.
thank you. Next up, we have Steve. Steve, thank you for your patience. Steve Morris has been a member of CAI for more than 20 years and holds a designation as a reserve specialist. He is experienced in providing services to community associations ranging from transition and reserve studies through major multi-million-dollar building rehabilitation projects, though he's still willing to go out and check for a roof leak if you need him to. Steve is licensed as a professional engineer in New Jersey, New York, and Pennsylvania, and has extensive experience in forensic engineering and expert witness services, and is a member of the National Academy of Forensic Engineers and as a senior board member, certified and credentialized diplomat forensic engineer. He has been qualified and testified successfully for the clients in court throughout the state, including Passaic, Middlesex, and Hudson counties. Along with being a professional engineer, Steve holds the following qualifications: New Jersey State License EFIS Special Inspector, EFIS Inspector Moisture Analyst, Hot Mix Asphalt Construction Technologist, and Structural Firefighter. Steve will talk about what an engineer expert witness typically does for community associations when an expert witness is needed, and what is to expect when working with an expert witness engineer. Welcome, Steve.
Great, thanks, Angela. As with everybody, I could talk for more than an hour on this stuff and for the daylights at everybody. So I'm going to be very high level, quick cover some important aspects of working with a expert witness, particularly an engineering expert witness. And then at the end, I'll try to give you a couple of tips on things to be aware of and think about when you're working with an expert witness. So forensic engineering is another term related for expert witness related services. And really what it is applying engineering and science to a legal dispute. Primarily today, I'm going to be discussing construction defect claims, because working with community associations, that's the most common time that we're dealing in the expert witness phase. Although there are claims, sometimes defense claims for slips, trips, and falls, and some other things like that. The general concepts that I'm going to touch on will cover everything, but primarily we're talking construction defects. So I'm going to outline some basic things that your expert witness will typically do. So number one, start with hiring the expert and agreeing to the scope of services. The expert's going to do an investigation of the issue, prepare a report. He's going to work closely with the attorney throughout the engagement, and then provide testimony in depositions and trials. So when do you need an expert witness? You need an expert witness when a dispute looks like it may end up in litigation. And often having a good expert witness involved early can avoid a litigation. You don't need an expert witness for everything you do regarding engineering. For a transition study, for example, you don't need an expert witness because your transition report is not a litigation report. It may end up leading to one down the road. So you don't need an expert witness, but it's beneficial if your engineer at least understands the concept of expert witness services, because if it does lead to a litigation situation, it can make it go more smoothly. So let me talk some specifics about what the services are. And I outlined it briefly. So number one, and the most important part, is understand the scope of the expert's engagement. And this involves having the engineer involved, having the board involved, having the manager involved, and having your attorney involved. And everybody has to have the same understanding of what the engineer is going to do for you. It could be a matter of going out, doing a quick review of an issue and coming back with a brief memo explaining whether there is a problem and there's a viable claim, or you may be engaging that expert to go do a detailed investigation and come back with a court-ready report. You got to make sure everybody understands what that engagement is, put it in writing, make sure everybody has agreed to it, so there's not problems and disputes down the road amongst your own team. So then once you're engaged with your expert, number one is that expert's going to need raw records and documents. So start with gathering all the plans for the community. That could be architectural plans, structural plans, site plans, landscape plans, anything, any set of plans you can get your hands on, get them scanned, keep them safe where you can access them, and then share them with your expert as needed. Work orders and complaint logs are very important. Most management companies have some system for tracking work orders. Make sure that everything is captured, you've got good details, and then it's in some sort of a format that you can share with your expert, and they can sort it and organize it and use it as a database. Vendor contracts. If you're engaging a contractor to build decks or replace stoops or something like that, make sure you keep good track of the contract, the specifications for the work, the invoices, the payment recommendations, all those sorts of things. Particularly if there's a dispute coming, make sure you've got that organized and well recorded, because your expert's going to need that. And any reports from maintenance contractors, or if you get an annual fire inspection, keep good track of those, because if you have a dispute with one of those, you need all that good information. So once your expert's done that preliminary review, they got to come out and do an inspection. And again, I could talk for hours about inspections relating to expert witness services, but it can go anywhere from a visual walk around, a visual inspection, to detailed invasive inspections with pressure chambers and water spray racks and scaffolding. So it's really important that you start talking early with your expert about what's that's going to look like. And be aware that if you're doing any sort of investigation, that anything more than really just looking at something visually, any other parties in your dispute are probably entitled to be there when that happens. So make sure that you're keeping your attorney advised so they can put any other parties on appropriate notice, because you don't want to go out there and start cutting things apart if the other parties weren't aware that it was going to happen. The report. Once your expert's done their investigation, they're going to do analysis, they're going to review it, and they're going to prepare a report. The report is basically the make or break deal in this whole process. A good report is going to encourage the other parties involved to settle for a more favorable settlement for the community. Now, there are court rules about what has to be in an expert report and what that report has to show. So it's absolutely imperative that that report hits all those marks. It's a lot like preparing a good meal. If you have a list of ingredients, if you don't get all those ingredients in there, it's not going to work. Same thing with an expert report. If you miss a critical component, there's a good chance that report could be thrown out. And if the report is thrown out, your expert testimony is probably going to be thrown out. You're going to have a big hole in your case. So you got to make sure that you get a good report. You have an expert that can prepare a good report, and make sure your attorney is comfortable with that report before it goes anywhere. When you're preparing the report, it's got to be comprehensive. That report is going to serve as the basis of your expert's testimony on trial. So if there's an issue in dispute, if it's not addressed in the report, you probably can't bring it up in trial. So make sure that if you have a concern, you have an issue, something you're trying to make a claim on, it's got to get into the report one way or the other. And again, a strong report is going to encourage the other side to be more favorable towards you in any settlement offer that may be made. There's a good chance that that report is going to end up in the hands of a insurance adjuster for the defendants. And if the report is well structured and it's a strong report, that defense expert is going to be more likely to want to encourage their side to settle, because they're not going to want it to be presented to a jury where they might get a really hammerhead settlement on them. So, and in the opposite, a weak report may telegraph a weak case. So make sure that everybody's very happy with that report before it goes out. That being said, even the greatest report, when it goes out, there's going to be a rebuttal report. So you could have a perfect report, greatest report, guaranteed you're going to get a report back from the other side that tells you all the things that's wrong with your report. Your expert doesn't know what he's talking about. Don't get upset. That's to be expected. That's part of the process. So just expect a rebuttal report. Expect that it's not going to agree with everything your guy said, and you're going to have to respond to it. So, well, the expert's going to have to respond to it. So just be prepared for that. Once the report's out there in the world, the expert's work's not done. Really, through the whole process, your expert's going to need to work closely with your attorney. The expert's going to help the attorney evaluate the claim in the first place. They're going to discuss legal theory and merits and weaknesses of the case. You know, it's important for the expert to point out the weaknesses in the case to the attorney to make sure that there's no surprises down the road. They're going to review and discuss parties that may be subject to the claim, subcontractors that maybe were involved. They're going to talk about defense reports and rebuttals, settlement offers. So there needs to be a close, good working relationship between the attorney and your expert. And then comes testimony. So there's going to be depositions, and the deposition is the other side's first chance to see how your expert does under pressure. So your expert needs to do a lot of preparation, be ready to go when that deposition occurs. And your expert can also learn a lot on the defense side during that deposition. And then trial. Trials when everything, you know, when it really matters. So the expert's got to be very well prepared. And one of the things that sometimes gets overlooked is exhibits. The exhibits are what's going to help your expert tell the jury the story of what you want them to understand. So make sure you've got good exhibits that are intelligible to lay people, and there will be expenses for that, but that's some of the best money you can spend. So just in closing, real quick, a couple of tips for dealing with your expert. Number one, and this is really important, all communication should go through the attorney to keep it privileged. You don't want board members sending emails to your expert. You don't want the expert having phone conversations with the board unless your attorney's involved. Really important. Don't let the board feel like the expert's not respecting them because they're not responding. So make sure they're aware of that. And don't ask your expert to do a presentation to the membership unless the attorney is present. If they do a presentation to the membership, they're basically going to show the playbook of your case and guaranteed that information is going to get back to the other side. So be very careful about what is actually presented to the membership in open session. So that's my 13-minute review of everything you ever wanted to know about expert witness services. So I'm ready to answer questions if anybody has any.
Yes, thank you, Steve. A couple of questions. First up, why can't an expert witness tell the board exactly what it will cost to prepare a report and get them through trial?
That's a great question. So in part, in the process, when an expert goes out, and I'll use an example of a roof investigation. If there's a problem with shingles, the expert may go out and look at the shingles, and in the process lifts up the shingles and now finds out that there's a problem with the plywood and a problem with the siding. So a lot of times it's kind of the layers of the onion as the process goes on. In addition, the expert doesn't know what response he's going to have to do. Are there going to be rebuttal reports? Are there going to be mediation sessions? So there's so many unknowns, it's really difficult to give a number up front.
Okay, and the next question, if there is a small claim, can the expert just do a brief or a limited report?
Not really. And as I mentioned, there's certain requirements for what has to be in that report. And getting all that stuff in properly is critical. And that even includes very specific support for any opinion or position that your expert takes. So all that's got to get into that report, and trying to limit that and do it briefly and quickly may end up with a report that could easily be thrown out. And if that happens, your whole case is going to go away with it. So it's not a good investment in time. And it's also a risk to the expert themselves, because if they have reports that get thrown out, that's the sort of thing that'll stick with them down the road. So be careful in checking to see if your experts had many reports thrown out.
Okay, thank you. Those are all the questions. Do any of our speakers, thank you, Steve. Thank you so much.
Sure.
Any other remarks from our speakers? We have a couple of minutes. I don't know if we missed anything. Any last thoughts from anyone? You really covered the topics so well. Thank you. All right. Then those are all the questions. I just want to let our attendees know, if you think of anything later on, you want to address any of the topics, please feel free to email us at the chapter office, and I'll definitely get you in touch with the presenters. As far as managers, please feel free to email us for your continued ed credits, and that's all we have for today. Thank you, everyone.
Thank you for having me.
Bye-bye. Thank you.